Any mention?
Yes, Mr.
May please, Lordship. Lordship, I beg to mention item number 8, Lordship.
Please on the other side.
Lordship,
Yes.
Lordship, due to non-availability of the arguing counsel, Lordship, Mrs. Lordship, and appear matter may be urgent for a week, Lordship.
For a week. Is there any use of taking adjournment on a weekly basis when the matters are not taken up? If you see order sheets of these cases, just see how many orders of adjournment. It is always better I take a bit longer time, but then make sure you take up the matters. Anyway, madam, any objection?
No, Lordship, no objection.
1 week. At the request of the state respondents, at the request made on behalf of the state respondents, this is matter of common. Yes.
I look, Lordship.
Obliged, Lordship.
My please, Lordship,
Yes.
I beg to mention, my Lord, yesterday land acquisition matter. Lordship, remember yesterday the hearing.
Yes.
The other side also here. There were 2 missed cases where Lordship passed an order for protection.
Yes.
And Lordship passed an order yesterday that those interim order will be continued till the next date,
Yes.
after a week. But we have checked the order sheets, my Lord. With regard to missed case number 139,
Yes.
my Lord, there is no such order. And when we verified, my Lord, it was not listed, though Lordship passed an order to be listed yesterday. So, my Lord, to avoid confusion on the ground,
No, in both the matters, there were 2 missed cases filed here.
2 misses we filed.
So, in both the matters, we have passed an order for continuation of the
My Lord, with regard to second missed case, there is no such order.
Yes.
So, if Lordship clarify with the registry,
There are 2 missed cases.
missed case
No,
number,
if order is passed today, then it is not required to. This missed case was not there yesterday in the list.
my Lord, we have reject again.
What are the missed cases?
My Lord, missed case
Just
number
give the
139.
missed case numbers.
Yes.
2 missed cases for interim order. Yes.
Yes. With regard to this, my Lord,
Yes.
it was
139.
not this. Yes, Lordship fixed the matter 7-8 yesterday. And yesterday, my Lord, when the matter was taken up, it appears that this missed case was not listed. And therefore, perhaps it is missing in the order sheets. So I've informed the learned GA also. He has no objection, since the Lordship made it clear yesterday. Only Lordship.
So it was not there in the thing.
Yesterday, yes.
Yes.
Because of that, I think. Although the rest, Lordship made it very clear yesterday that interim protection will
This
continue.
matter was not there. 139 was not there in the list. Listed. It was order to listed in 7.
Yes. Perhaps registry overlook.
But then it was listed for specifically for this 7-8. See, this order says it's listed in 7-8. It's the other case. So this yesterday's order is not there in the thing.
Yes, yes.
That will come then. Then that will be, this order will be there. These things.
But
We'll do, see, because this matter was there. Probably it has not been shown in the cause list.
Right.
But then it was put up with the thing,
Right.
with the main case.
Right.
So somehow probably it was missed.
Right.
So this extension order will be uploaded there.
It is uploaded with regard to only single missed case filed by a single read petitioner. So because of that, may it be on the ground. Confusion may be
There
there.
are 2 orders we passed yesterday. But
Only one.
where are those missed cases? What are those missed case numbers? Okay, this will be very well.
My Lord.
Accordingly, order will be up.
My Lord. Give you.
Just make sure that same order should be in 139 also. Yes.
May please, Your Lordship. Lordship, I beg to make a mention item 11, Your Lordship. Lordship, I pay for week's commutation, Your Lordship.
Item 11.
11, Your Lordship. I'm for respondent number 2, Your Lordship.
Yes.
My Lord, I am for the petitioner.
Yes. When do you vote it?
Week's time, Your Lordship. Week's time.
Today, they did not inform me also in advance.
At least do that. Have that courtesy at least.
My apologies, Your Lordship.
Yes, sir. 11 as the request made on behalf of the respondent number 2. What is this matter for 2 weeks? Yes.
Lordship, item 12. Lordship, this is a legal aid matter, Your Lordship.
Which one?
Item 12, Your Lordship.
Yes.
I'm mentioning on behalf of Miss Adata, Your Lordship. Lordship, I'm praying for a week's time, Your Lordship, in this matter.
No objection. Other accused made on behalf of MS Ardapta, London Legal Aid Council, appearing for the petitioner. List this matter after 2 weeks. Yes.
Any right.
Submit to court list. Item number 1.
May I please, Your Lordship?
Yes.
Well, there is an application for quashing the FIR which is registered in Tura, Haramal Police Station. My lord, may kindly come to the FIR fast. My lord, I would like to take my lord to the FIR.
Yes.
Here I will brief.
Where is the FIR?
The FIR is on page. FIR dated 7/3/2024, my lord.
What is the page number?
Page number 57, my lord.
Yes.
I am permitted to read this FIR.
Yes.
To the officer in charge, Tura Police Station, West Garo Hills, subject FIR, dated 7/3/2024. I am the license holder of the bonded warehouse by the name and style of so-and-so warehouse. I am appointed Sri Gopal Kishan Gaur, my lord. I am the petitioner, my lord. Son of so-and-so, resident of so-and-so, Tura, as a manager to look after the affairs of the warehouse under his full control since February 2004, my lord. Now, to that effect, my lord, and power of attorney was executed between the party, my lord, by the complainant and by the accused, my lord, who is the petitioner before this order.
So he was the attorney holder or he was a manager?
He was an attorney holder first, my lord. Now, my lord, in the year 2021, September month, he handed over the control of the warehouse to me, stating all government dues are clear and the remaining stock is in godown. However, late I learned that excise duty amounting to crores of rupees is due to the government and the godown was empty. He has misappropriated all the money which are due and now he left Meghalaya and his whereabouts are unknown. Further, he has transferred huge amount of money from the bonded account to his and his other relatives' account. I seriously doubt that he has also forged my signature. Now I am not being able to contact him and he has probably changed his mobile SIM card. The above act of so-and-so to cheat, misappropriate, fraud, forge and stealing and also cheating a person belonging to ST. To the best of my knowledge and understanding, Sri so-and-so is fully liable and answerable to pay all the liabilities and dues against my bond. My lord,
What is
the allegation?
This FIR was registered under what section of law?
My lord, the FIR has been registered under, my lord.
Not by invoking SCSC Act, isn't it?
No. This has been registered under section or all other sections of IPC, my lord, 406, 417, 420, 4365, my lord.
Yes.
I mean, after this FIR has been lodged, police has called me in few occasions, my lord. They have not issued any notice under section 41, my lord. They are just calling me. So I am apprehending that, my lord, I may be arrested if I am here, my lord, because the FIR has been lodged with enclosing 2 documents, my lord. 2 documents, the deed. If my lord may kindly come to page 58, my lord, first. This is the forwarding report, my lord. In the forwarding report, if my lord may kindly see the enclosed.
Page 58.
58.
It is inquiry report.
58, my lord.
5A. Annex
5A.
5. Yes.
Page 58.
Exactly.
Yes, my lord.
Inquiry report.
Yes, it is an inquiry report. Yes, my lord. What I want to highlight in this, my lord, the enclosure, my lord, in this inquiry report is the original FIR, original deed of agreement of both the parties. Now, my lord, I would like to take my lord through the general power of attorney, which was given to me, my lord, by the complainant. That is on page 32, annexure 2 in series, my lord.
Yes.
My lord, may kindly come to clause 1, my lord, that he shall pay the government in advance per annum a fees of rupees 50,000, such amount as may from time to time be raised by the government through the Tura treasury after getting the challan approved by the concerned official of the department. So I was supposed to pay, my lord, annually 50,000 to the government. So I was taking care of everything, my lord.
That
Now-
is one of the function.
Yes,
Not
yes.
the entire function. There
Not
are
the
other
entire function, my lord. That is one of the function. Now, my lord, may kindly see page 36. I'm just taking the relevant portion, my lord, which
So
I'm.
that, but then under 482, how much? To what extent we can go? The FIR discloses.
Yes, my lord.
the commission of offence
That
against
is what
you,
I'm
let
coming
it be
to.
inquired into.
I'm coming to, my lord. Now, my lord, may kindly come to page 36, my lord.
Yes,
Serial number 11, my lord.
yes.
That he shall be bound to maintain such minimum stock of foreign liquors and spirits in the bonded warehouse as may be from time to time fixed by the excise commissioner. Now, my lord, may kindly see, after this power of attorney which was given to me, general power of attorney, an agreement was signed. This power of attorney was signed on 29th of January 2004, my lord. Now, my lord, may kindly see in page 42. There is a deed of agreement which was given by the complainant, which is executed in fact, my lord.
Yes,
Page 42, my lord.
yes.
The first power of attorney was on 29th January, my lord. Now, this is on 1st February 2004. That means within a short span of time, my lord. Whereas the first party has been licensed by the government of Meghalaya in excise department to establish and run a bonded warehouse for storage and sale of the so and so subject to the terms and condition mentioned in the license. Now, my lord, may kindly skip the next paragraph. Next paragraph, if my lord may kindly come. Whereas due to some reason she has been facing acute financial crisis also, and she therefore approached the second party. I am the second party, my lord, to make necessary investment in the business of her bond and also to utilize his expertise and business in the running and management of the bond, my lord. That means, my lord, she has seek help from me to invest the money, my lord. Now, my lord, may kindly come to page 44, my lord. Clause 1, my lord, that this agreement shall be effected on and from 1st February 2004 and shall be valid for a period of 5 years, on the expiry of which period the agreement can be extended, renewed by mutual consent and subject to such unalteration terms as both the parties may decide upon. Same thing, my lord. My lord, may I kindly see clause 2, my lord. The first party has already applied for changing the name of so and so bond. The second party has already deposited a sum of 1,20,000 rupees. Only being the licensing renewal fees for the year 2003-2004 by TC number so and so. This money has been paid by the second party. So my investment, my lord. Now, my lord, may kindly see the third point, my lord. On and from so and so date, the second party will be.
What is the purpose of reading all those things before?
My lord, it is this agreement. By this agreement, my lord, power has been given to me. I have invested, my lord. Now, my lord, what was the allegation that there was no more stock, my lord? I have enclosed the stock register, my lord. My lord, may kindly see the stock register.
Do you want to say that you are running the other's business? Or is it a kind of Benami transaction?
No, it was not a Benami, my lord. They have asked my help.
See, the thing is that some allegation has been made, rightly or wrongly,
My lord.
that requires to be investigated.
Correct, my lord.
This court is. It will
I
not
totally
go
agree.
into. You see, that the thing is that you know the subtle proposition of law so far as the quashing of FIR is concerned, guiding principle that Bhajan Rao's. Now, at the stage of quashing, this court is not supposed to take into consideration the documents which comes at your instance.
Exactly, my lord. Exactly, my lord. My contention is this, my lord. After this agreement was given to me, my lord, that has been revoked, and all the power of mine was seized, and I have handed over. An NOC was issued to me, my lord, by the complainant that there is no due against of me. That is on page, if my lord may kindly produce, my lord, page 49, my lord.
How do you know how much? What is the admissibility of that document?
Well, it is her signature, my lord.
How do we take it as a correct document?
My lord, may kindly see, it is all agreement,
That is, you are saying.
notarized, my lord.
You are saying it is her signature. We do not know. And this court doesn't have any expertise to see it.
My lord,
See, you should understand the limit, Mr. Day. You are a seasoned lawyer. It is not that.
my lord, may kindly produce 2 more documents, my lord. And that, if my lord may
No, see,
think, my lord.
which way you can enter these documents? Anyway, see, we may issue. Yes, madam. What do you
My
say?
lord, before my learned friend submit, my lord, my submission is also this, my lord, on being instructed, my lord. I am ready to cooperate with the investigation. If any tax which is I am supposed to pay, my lord, I am ready to pay, my lord. I am ready to pay, and I have given an undertaking.
That should be that. See, proposal should go to the person who has filed the
But if
what,
this is
what
a
state would do? They are not before us till now at this stage, is it?
my lord.
We'll just wait. Let them appear and we'll
So
see.
my lord, only a limited prayer, my lord. No coercive action may be taken. I will cooperate in the investigation, my lord. Otherwise, my lord, they will arrest.
If you have anything, then you file an application for anticipatory bail.
No, my lord,
There is no question of.
my lord, I file a miscase also, my lord. For
Normally, in normal situation, you will not get.
My lord, may kindly consider, my lord, that application that they have given me, they have said that there is no dues against of me. Now they are saying, even then I have given an
These
undertaking.
are all documents appended by you, Mr.
My lord, but these are given by her, my lord, her signature, my
madam.
lord.
Well, now it's also settled law that in
So what is the
quashing
situation
one
now?
can't. My lord?
What is the situation? What is the progress of the investigation of this case now? And do you want custody of that man?
My lord, I'll have to seek instructions on that. But as far as the petition is concerned,
What is the section involved in this case?
My lord,
what section?
it's
section 406, 417, 420, 465.
So that is okay. So punishment is 7 years. So 41A will come.
yes, my lord, they are not issuing, my lord.
So definitely you do not have any apprehension of arrest then.
Lord, he has
That
just
may be
received phone
recorded, my
call.
lord, my lord.
He has just
That may be
received a phone
recorded, my
call
lord.
to come to the police station.
We'll just issue
That-
notice, Mr. Let this. You take steps for service of notice.
At least, my lord, may kindly see the NOC part, my lord. Only if my lord may produce the NOC, that she has given me a clean sheet. And this is the document she has signed, my lord.
Mr. Day, why not you produce all those things to the investigating authority?
My
You
lord, that
say
is
that you were called. Let them take a call on this.
That is why my lord, minimum protection, my lord. No
See,
coercive action may be taken against of me, my lord. I am ready to go tomorrow, my lord. I am ready to go tomorrow, my lord. No coercive action may be taken against of me, my lord. I am ready to go and give all these documents, my lord. Whereas in the FIR, they have never given these documents, my lord.
Let them obtain instruction and then we'll issue notice. So we are not passing any interim order.
Well, on the meantime, my
It
lord.
is your own admission. You say that you were called and all. You have not been picked up. So what is the question of detaining you again?
My lord, I cannot follow.
You yourself have made a submission that you were called by the investigating authority and you cooperated with them.
Yes, my lord. I have cooperated, my lord.
Once you are not taken into custody and then this FIR is of March. In the March, it was lodged.
But there is a delay of 3 years, my lord, and FIR has been lodged, my lord, after 3 years, my lord.
That investigation will reveal. You see, that is a different thing. See, you don't just do not drag us to the merits. Yes, madam.
My lord, highly obliged for the observations my lord has made. I would just like to submit that it's a premature stage to even quash the proceedings at this stage. My lord may still issue notice.
Why premature stage?
My lord, because investigation is going. Preliminary report already shows.
Allegations made in the FIR,
my lord,
has no connection with the actual fact. Then why it is not premature? Why it is premature?
My lord, there is a connection with the actual facts, and in fact, they have been saying that they will be. If my lord may kindly see the inquiry report, it's a preliminary inquiry has already been conducted. Page 59, 58, 59 both.
You do one thing. We'll have it next week. You take instruction.
My lord, obliged.
On the
Especially
meantime, my
whether
lord.
you need custody of the person or not.
Obliged.
Well, on the meantime, my lord, I am no coercive
You
action.
have not been taken into custody all this, so you do not need. We are not passing any interim orders. We'll just say these things. Let's just wait. When can you have instruction?
Let it be on Monday, my lord. Then
When can you have instruction?
we have 4
this is
days.
from
my
which
lord.
police station?
Next
Let it
week.
be on
next
Monday.
week.
Hmm?
Next week. Thursday.
Next week, Monday, my lord.
How long will it take? Just say
Thursday.
Tuesday, Wednesday.
Thursday, my lord.
Let it be on Tuesday, my lord.
My lord, we request the Honorable Court, please.
Somebody is addressing, please. If one council is addressing the court, let him come. Pass the instruction.
My lord, let it come out on Tuesday, my lord. Because the person is very old, my lord, and if he is apprehended, my lord.
Mr. Council for the petitioner. and also MSI, not G, applying for the state. List this matter again. Just give to state. In the meanwhile, the landed GA shall obtain necessary instruction in the matter.
Then my miscase also be placed on that day, my lord. My miscase is also.
What is the need of filing a miscase separate?
Well, only no coercive action, my lord.
Include that power. What is the thing? Miscase also listed on this thing.
My lord.
Just. But then there is no need. We do not need any miscase for passing an interim order.
No, it's not that, my lord. But it's still, from my side, I have filed it, my lord.
Unnecessary increasing the volume of the file.
No, my lord. Only thing, my lord, if my lord will consider the NOC that has been given.
Mr. Day, you can understand. We have a limit. You see, it is not that we can.
But
take
if
into consideration
someone,
the merit of the entire
my lord has already passed an order, I will not ask my lord to change the order. But my lord, if someone want to victimize me, my lord, on the basis of the document that they have not produced, my lord.
You know your things. We do not know. We just go by the records and we go by law. That is why.
My lord, let's come on Tuesday.
But I mean, take instruction specifically with regard to whether its custody is needed.
Well,
May it please your Lordship. Lordship, this is the case by virtue of the interim order. The petition is continuing service, your Lordship.
Who is appearing for the petition?
Surge High Lordship.
He's not there. On the last occasion also he did not appear.
Lordship, but I would like to draw your Lordship attention to the affidavit being filed by the petitioner on the last occasion, your Lordship, dated 23rd July 2024.
No, if they are not appearing, we'll dismiss the matter. On the last occasion also they did not appear.
Your Lordship, they have made a mistake in the petitioner, in the affidavit, your Lordship.
See, if they are not there, then why should we go into all this? No, but there is no one.
Your Lordship, actually the petitioner concerned here, your Lordship, he has not sworn the affidavit, your Lordship. Instead of Saiju PV, it has been sworn by Mr. Dharmendra Singh, your Lordship.
Anyway, it's all right. You just keep these things.
Okay.
We are dismissing this matter right now because of the default. There's no one. None appears for the petitioner when the matter was called out. Stop. MS K. Guru is present on behalf of the respondents. Stop. On 24/7/2024 also there was no representation on behalf of the petitioner. Stop. It appears that the petitioner has no interest to pursue this matter. Accordingly, the matter stand dismissed for default. Yes. Two non-appearances. On the first non-appearance, we do not dismiss. But then, if there is two consecutive non-appearance, matter will dismiss.
Similar matter, your Lordship, item number 3 as well, your Lordship.
That shows the order sheet. Item?
Item number 3, your Lordship.
What 3? This is item number what?
2.
Okay. Item number. Same order. Same order is this. WBC 222. 2. The next one is 222.
Much obliged, your Lordship.
Item number 4.
My lord, may I please? In this case, when I approached the RTI, I got 5 communications. The TRI gave me reply to me that it had sent the application to the DOT, Department of Telecommunication at Delhi, and from there Delhi they sent it to Guwahati branch, and from Guwahati branch on 10th July they gave me communication that the information is not available. Then on 5th there is a communication by the
what is to be done with all those
CPIO that
See,
they have given the
Mr.
name and
Vora,
address of the appellate authority.
What this court has to do with all those things?
Yes, I have to file an appeal. They have given me address of appellate
against
authority
what?
also.
RTI.
RTI appeal.
Then it's okay, but then this matter we are not dealing with RTI, isn't it?
Yes, yes.
This matter we are dealing with at this stage.
Yes.
Taking up steps again. That's 152.
Yes.
Now your difficulty is that you do not know their address.
Yes, ma'am.
Go for newspaper publication.
So through RTI or others, it will take because it is a criminal proceeding. Strict evidence is required. Now, I have paid money online to these SIM card holders, and the vehicle has been found with this respondent.
You are going to the facts. Right now we are not into all those things.
Yes, yes.
Well, we are concerned with the service only.
The notice has to be received by this.
To make some people as a respondent. Now, they should definitely have the notice of this case, isn't it? Now, if you are unable to find out their address, then go for newspaper publication.
Yes, so I need more time than mere adjournments time and again. So I want to pray that the case may be kept sine die till I find the addresses of these people.
We cannot adjourn it.
In that case, a long adjournment may be given.
You see how long your appeal will take?
Yes, yes.
Just for this, we cannot do it.
So 2 months time may be given
initially. Otherwise, you withdraw this matter and you file it when you get there.
I may be given 2 months time.
We cannot give you 2 months time for taking steps.
See, 1 month.
Even 1 month also for taking steps we cannot. This time and again they have given you time. This is unheard, you see.
Yes.
That is your duty to find out.
Yes.
And then you should take effort to see this notice served.
Yes, ma'am.
If you cannot, is there any supplementary this thing? Any alternative way of serving things? What the law is?
I have not tried through the bank. I'll try through the bank also.
So that is your
Yes.
thing, which way you
Yes.
try it. Only thing is that, you see, at the best we'll give you 2 weeks more, and then we will not give this one.
Yes, sir.
Thereafter you should take this things. Yes, madam, we'll just give him 2 weeks more. He has some difficulty. We cannot help him in this situation. So that is the problem. And
Lordship,
we cannot keep this matter pending also on account of the
the matter
difficulties.
concerns Zimma being granted to one of the respondents. What can possibly be the correct recourse, my lords? Because this is not the right. I mean, Lordship,
The dispute here is actually that the Jima was not given to the person who had the vehicle was not registered on the person whom the Jima has been granted by the court below. That is the main issue actually.
Who is the registered owner? Are you the registered owner?
he's not.
No,
Then?
I'm not. That is why.
Then?
He's not. So we
And registered owner is not before us.
not before us, Lordship.
Then what
Registered
case we
owner
have?
is there.
Firstly, the revision itself will not lie, my
Brahma is
lords.
the registered
That'll come for
owner.
later. But
Jagat Brahma is the father of Hitesh Brahma. Hitesh Brahma, the respondent 3, is the registered owner. But it has been given to his father. That is the dispute.
You don't know, see, like, you do not know what relief you will be entitled to.
These addresses are very important.
We'll give you as
review itself, man.
this is very difficult. You see, this is, see, last all the orders are about only taking steps.
The main dispute in the petition is that the Jimma was given to a person who is not the registered owner. Registered
We are
owner is
concerned with
respondent
notice.
3.
How does he gain,
Jimma is given to
lordship?
No, no,
respondent.
but then if it is not given to the registered owner, which way you are agreeing? What locus do you have?
I am the complainant. I have paid money for that vehicle.
That we do not
I,
know.
sh-
That is yet to be-
I
that
should
is
have
yet
been
to be
given a
determined.
notice by the court.
What is the,
Because
see,
the case
you are-
itself, based
you are-
on the payment I made online
you are
on
in
the
a,
that
you are
vehicle.
in a divisional jurisdiction. You just cannot make out a case of appeal here by going into merits. And
No,
saying
the
that what should have been
initial
done or
case
should not have
started
been
with
done.
with this
Did you
complaint
file
that
any
I
application
paid
for
for that
Jimma?
and the
Did you
vehicle
file-
has been given
Did
to
you file
somebody
any
else.
application for Jimma before the trial court?
I did not. I'm not the registered.
What is
No,
what is
the
your
thing is that
process?
it has not been given to the
You have
registered
not, you have
owner.
not asked for, you have not asked for this thing.
No,
Jimma
I
is
have
a
not
vehicle.
locus stand. I am not registered owner. But
We are
the court had to
disputing-
give to the registered owner. It had
Have
given to a person who is not the registered owner. That
Did
is
you,
the dispute.
when this matter was pending for grant of Jimma, did you file any application claiming Jimma
I am
of
not the
vehicle?
registered owner. How
Did
can
you-
I file?
Did you file it, Mr. Argo?
I have not filed any objection
That
there
is-
also. I
that
didn't
is-
get
that is
any
your answer.
notice.
You have not filed an application. What locus you have? You do not have any locus.
Initially, I am the complainant of the case. With that locus standi I came.
You are the complainant. What the complainant
Police has done the
complains doesn't mean
investigation.
that you will have a right to possess.
Then the court below has given the Jimma to a person who is not the registered owner.
Naturally,
That is the dispute.
that's the problem. That is a cause of action for the registered owner. You are not the registered owner. So
But-
which way you are agreed?
The court had given an erroneous judgment. It should have given it to the registered
See,
owner.
you are
But
you
the registered
exercise-
owner was
you-
also
are you
there.
exercise jurisdiction in public interest litigation?
So I am as a complainant. My locus standi as the
No, no,
complainant
you are
of
as a
the initial
complainant, you
FIR.
have- The fact remains that you have not filed any application of Jimma. That is
No, not before the
that is
court
a-
below.
That is enough. That is enough. You cannot make a claim then. Then what remains?
No, my claim is
You want to
that
proceed with
in the
this
case
case?
which started with my application,
Madam, we
my
have given him the
complaint.
opportunity to taking steps for these things. So at this stage, we will not pass any order of disposal. We'll just give him further 2 weeks time.
Yes.
If he fails to do so, we'll just decide. See, it appears from the related office notes that in spite of several opportunities, the petitioner has failed to take steps for service of notice upon the respondent number 528. Mr. P.K. Bora, petitioner appearing person, submits that he has difficulty in ascertaining the correct address of the said respondents. He prays for grant of some more time to enable him to find out the correct address of the respondent number
5678.
5678 and to take steps for service of notice upon them. Give paragraph in view of the submission. Another further, not say another, further 2 weeks time is granted to the petitioner to take steps for notice of service upon the respondent number 528. Huh?
She's for 4. So 2 and 3 are also.
List accordingly.
No, not about.
Yes. For the next.
Hearing item number 5.
Obligement.
Yes.
Well, this is a case taking over of possession of certain land, my lord, without
Land acquisition matter.
without following the acquisition process.
Your land has been taken over.
Yes, my lord.
By the state.
By the state.
Yes. And then
That the state is disputing, my lord, that this is a land, this is a road which has been constructed, is a land comes under ROW. No, my lord, at the time of British time, my lord, there were only 3 meters road. That road has been extended now to 20 to 30 meters, my lord, in a wide level.
When this road was constructed?
It was in the year 2006, my lord, if I'm not mistaken.
Now, this was an expansion of road.
Expansion of road.
And because of that expansion, your land suffered. That
Yes.
took away your land.
Yes, my lord.
And then what happened? You made a claim. Was there any acquisition proceeding for
No,
widening?
there was no acquisition process.
So now, is it not that it becomes a civil dispute then?
Oh, my lord, here the question is that an inquiry report was also been called for by the this honorable court earlier. My lord. So there it has been admitted that they have crossed the construction beyond line.
Beyond ROW?
Yes, my lord. This is an affidavit in opposition file. It is
So
also
what is your prayer in that petition just come?
my prayer for compensation, my lord.
Compensation of for how much of land? Yes, Mr. Day, you want to say?
Yes, my lord. I have an objection on the maintainability of this petition, my lord.
You are appearing for?
I am appearing for district council, my lord.
What acquisition proceeding what district council has to do?
No, my lord. That is what we are coming, my lord. This
That is
entire
only
land.
Mr. Hazarika who will be defending this case.
Yes, for the land acquisition purpose, my lord. Now, before it was handed over to the government of Meghalaya, my lord. It was under the Assam, my lord. And then, my lord, when the bifurcation of the district council, of the 3 district council, in 1972, if I'm not 1972, 52, my lord, 1952, when the district council was made, my lord, this entire land was given to us, my lord. Now, my lord, may kindly see why I'm saying that this petition is not maintainable. It is because of Rule 23 of the rule under the Land and Revenue Regulation, which says, my lord, I will just read out, my lord. Clause 1 says, nothing in this rule shall entitle any person to obtain a lease in respect of a land within 35 feet of the center of a public road. Any person occupying or encroaching on such land shall liable to be ejected under Rule 18 of this rule. Now, my lord, their claim is this, my lord. Their land is adjacent with the
No, but then why you are talking about the maintainability? Just
because, my lord, it's not
you are arguing the maintainability.
Yes, because the rule is not been challenged, my lord. The rule, if
No,
they are
his case is not that. That his case that you have taken his land which falls beyond ROW, beyond the 35 feet.
No, my lord, that is not correct, my lord. My lord, may kindly come to the report that we have.
No, report will see. Let him present his case.
My lord.
You are coming to merit, Mr. Day.
My
I
lord.
thought that you will raise some question on maintainability. So if you argue maintainability, let Mr. Nath finish.
My lord, on the point, my lord, it is. I would like to point out the page 15 of the writ petition.
How many petitioners are there, Mr.?
There are 2, single one here, my lord. There are 2 cases, next case is also.
And what is the description of your land?
My lord, that is, we could not give the description, my lord, because the part which has been taken, my lord,
No, how can
there's
see if there is no description of your land, then how? What basis? What is?
my lord, it is there in one patta is there, my lord, which has been annexed in the affidavit in opposition, my lord.
In your writ petition, why you are trying to make out a case on the basis of affidavit in opposition? If you say affidavit in opposition, then we will accept the entire affidavit in opposition, and whatever is there against you also, that also we will accept. That is Asian Development Bank Road.
Yes, my lord. Through this construction was made.
Is it that the cause of action arose in 2006, Mr. Nath?
Yes, ma'am.
How come you get to now? What is the?
I filed it in the, my lord, it was
2016, 10 years.
no, initially it was filed, my lord. Thereafter, some for technical error, my lord, it was again filed.
When it was filed?
Initially it was filed, my lord. I
There
think
is nothing to show that it was filed.
2013, 14. My lord, some papers are missing in my file. We have reconstructed it.
What is the status of construction, Mr. Hajarika? It's completed.
It's completed.
There's nothing in your writ petition, Mr. Nothing, not even a single matter. There is another writ petition filed.
Yes, my lord.
And it was still pending.
Yes, my lord.
What happened to that?
What they have done, my lord, in that now they have challenged the authority of the district council to issue patta. They have gone to the division.
What happened to this writ petition number 232 of 2016?
That has been.
This is pending for hearing, my lord.
Where?
316.
No.
232 of 2016.
It's a connected matter, my lord. It is listed today, my lord. 316.
316 is there. Who is representing
the same representative?
No, are you representing in 316 also?
No, my lord.
316, no one is appearing.
No,
It was filed by my learned senior only.
No,
His
but
name
then
is reflected.
all along you made this thing. Your name is there, Mr. Nath.
Yes, my lord.
This
316. It has been
There are
listed
two
with
writ
5.
petitions, 314 and 316.
Yes, my lord.
No, writ petition number 232, Mr. 232 of 2016. What is the 232?
This is filed by the same. It was filed by on representation by the same person.
232. And then
But for the several petitioners, my lord. That construction was around 93 kilometers, my lord.
That's fine. We are not there. This matter is still pending, my lord.
Where? Which court?
This court, my lord. If my lord may kindly see the last order of 5-8, my lord.
Who is appearing in that case, Mr.?
Mr. Sangarasu, senior counsel.
Oh, okay.
With, for the respondent is R. Coldly, my lord. Government advocate.
It's all.
This matter will be listed after 3 weeks, my lord. And the last order was on 5th-8-2024 of this honorable court.
My lord, in that opinion, let be tagged with that case, my lord.
If it is not connected, then why should we see?
That area, it is total 93 kilometers, my lord. So there are so many petitioners.
No.
My lord, in this matter, an inquiry was held, my lord, as per the order of this honorable court. Inquiry was held as per the order of this honorable court, my lord. And that inquiry report is in our affidavit, additional affidavit.
There is
my
an
lord.
inquiry held.
Yes, my lord. On the basis of the request made by them, my lord.
Who conducted the inquiry?
Revenue officer, my lord. Revenue officer, district council, whereas the respondent government.
Who directed district council to do the inquiry?
Yes, my lord, because they are the record holder, my lord.
Of the land.
Of the land, my lord.
That is a different issue. See, it can be, but then in the acquisition proceeding, where is that affidavit?
My lord, that is dated August 2022, my lord. August 2022, my lord. 23rd August 2022. Additional affidavit filed by district council.
Sam Ricardo Armarak.
Yes, my lord.
Yes. And what is the report?
My lord, may I kindly come to directly to the last page, my lord, the page 4, my lord, of the report.
Page 4 of the report.
Yes, my lord.
Yes.
Provided that periodic patta will not be issued in contravention to the provision of section 23 of the settlement rules frame under the Assam Land and Revenue Regulation, and no new patta shall be issued in respect of the land within one chain 66 feet of the 35 feet reserve along road maintained by the state or the union government within specific order from the government. Finally, during my inquiry, it was found that the few stretch of the land under the present improvement and upgradation of the road are patta land, and the rest of the land falls under the Nokma Aking land. In the case of PWD road, 10 meters in each side from the center of the PWD road is reserved for expansion and upgradation of such road, and according to my opinion, since the expansion is within the reserved 10 meters, hence fresh acquisition of the land by the state government is not required, and moreover, in view of the fact that the fresh land has not been acquired by the state government, the question of compensation doesn't arise as per the provision of Assam Land and Revenue Regulation 1886. So, my lord, the fact is this, my lord, the law says that it is 35 meters.
This inquiry has not been challenged.
This inquiry has not been challenged.
Yes, Mr. Nath, what is for you?
My lord, as per the affidavit in opposition filed by the respondent 2 and 5, my lord. In page number 6, a letter has been written by the executive engineer PWD Road to the deputy commissioner South West Garhwal.
The affidavit dated, just tell, there are many affidavits, just say which affidavit. Affidavit in opposition filed on behalf of?
State respondent 1 to 5.
1 to 5.
Yes.
There is respondent 2 to 5. Is there anything 1 to 5? Any page? What is the page? You are referring to page?
Referring to page 6, my lord.
Page 6, yes.
Here, paragraph 5, my lord.
Yes.
In paragraph 5, my lord, it is admitted that, is reported that the improvement works are confined to PWD land which is 10 meters from the center line of the existing road, except at this area where works have gone beyond ROW, my lord. There is another report, my lord, presently.
Just a minute, just read, finish it. The road, except at so and so where works. However, yes, this is 2016, isn't it?
2016.
And when is the inquiry report came?
Inquiry report came 2017, my lord. So, what happened, my lord? If I can just brief this honorable court, my lord. when the roads are made, expansion are made, my lord, the soil, my lord, which is brought, my lord, certain soil has been dumped in his road, my lord, in his land, my lord. For that, my lord, that is not a road, my lord. It is only because of the cutting of the soil, my lord. Some of his plantation has been destroyed or whatever, my lord. That case, he can go for a claim, my lord, of this compensation for the destruction of the plants and all, my lord, for trees, plants and all, crops. But, my lord, for only for cutting the land, my lord, which is the PWD road, how compensation can be claimed by the petitioner?
No, even if we accept this, what this letter says, now this channel, such and such full falls where?
No,
Who owns that?
in this respect, my lord, that money has been paid.
Has been paid.
Yes.
On what basis you say?
No, because it is beyond this 35.
No, then where is the proof that you have paid money?
Money, because they have mentioned in the map.
Mr. Hazarika, if you say the money has been paid, then you have to produce the proof that you have paid. If that is your case.
No, some money they have paid for some person.
Whether in connection with this extra expansion of road.
That is what. Yes. We do not know. We have to see in this connection. You say like there should not be something spoken without any basis. You are supposed to speak on the basis of records. Now, Mr. Nath has pointed out that there are certain areas where you admitted that your improvement work went beyond this ROW.
Yes.
Now, if it is beyond that ROW,
yes,
of course, there is nothing so far as he is concerned that whether his land falls in those particular channels which are mentioned there or not. Nothing is there. But then you said that some payment has been made. So where are those details of payment?
No, my lord. In that respect, my lord, I have to get instruction.
But then if you are saying something beyond your affidavit, then becomes difficult.
No, some question, my lord, little question.
It is not mentioned in
See,
the affidavit.
if it is a little or very little also.
No, I am coming that one, my lord. It is there, my lord. 1 kata 10 lesser, 1 kata and 4 kata, my lord. That is total 1 bigger 10 lesser.
Then how can you see one way you say in your affidavit that there is no acquisition proceeding drawn. Then how, on what basis you are making payment?
No, because there is no procedure if it is within 35 years. We are not.
If it is beyond 35, then you have to have acquisition proceeding, isn't it? You are saying that you have paid some money. On what basis you have paid?
No, we have paid. That means we have some road is banned and this and that for a state we are going. Then
but then can it be something like that? That the officer goes and pays from his pocket.
No,
there has to be a legal way of paying, isn't it?
they might have issued some notice.
Do not say anything might. See, if you want to pay for acquiring land, then there has to be a withdrawal of acquisition proceeding. Where is that? Or you say that you just say that there this land was handed over on the basis of some agreement and all, something like that. You show us something.
One bigger something total. Three place.
If you say you have paid, kindly show us where your affidavit doesn't say anything. There is no whisper of payment in your affidavit. Then that is something is coming from your mouth.
Yes.
Now you say.
Because as per the map, my lord, as they have handed over to me, then I have seen that 1, 2, 3 questions. How many? 1, 2, 3, 4, 5. All this. It is there, my lord. They have mentioned in the map. Only from there I can guess.
See, you can guess and you make submission. No. Very irresponsible way of saying, Mr. Hazarika. You are making a submission on the basis of your guesswork.
It's not mentioned in there. Only from this map I have seen that some portion, a small portion, but there is no land acquisition. With mutual understanding with the landowner,
We'll record your submission. You place us the details, and then definitely, if you fail to do it, then we'll have to pass on.
This land is not.
So,
no, this land we have not.
No. Now you see, you are changing your thing. You say that some have been paid, then you just see.
No, it is for other person.
Who are the persons? Give us details.
How can it be related, correlated
No,
with
no.
this?
See,
when the
Mr.
affidavit-
Mr. Day, we can understand, but then submission is made on behalf of the government by the
Yes,
by
yes,
your
madam.
responsibility.
Totally.
So you have to take into these things. Otherwise,
Uh,
see, there was no case. So far as this thing was understood, the petitioner had no sufficient materials to establish a case. Now, Mr. Hajarika is making out
No,
something.
something which is coming out of the affidavit that is making me very curious
Because
to
he has stated, disclosed some fact which is not
beyond the
born
affidavit.
in their thing, which is not stated in their affidavit.
It is not related to the petitioner.
See, you have made a submission in this case.
No,
We are
as per
arguing
this-
case for petitioner. And you said that some people have been paid. You just give us the disclosures who have been paid and for which stretch of land. You have to give us the details. We will record this. There is no other option. Yes?
I will get the instruction regarding this point 5.
No, you said that some payment has been made.
As per verbal by lot writing, I didn't get.
No, but then
From the
verbal or writing, whatever it is, instruction is instruction, is it? Heard Mr. Richard, London Council over the petitioner. See, basically you are making out a case for the petitioner. That is what you are doing. So, but then since the submission has come, you cannot ignore it. Okay. So, heard Mr. Richard, London Council over the petitioner. And also Mr. You are appearing for respondent number?
Respondent number 3, my lord, I am appearing for.
Mr. V. Hajarika, London GA for the criminal
1, 2, 4, and 5.
and Mr. Day.
Respondent number 3, my lord.
During the course of hearing, Mr. Hajarika London GA submits that some amount of compensation has been paid to some persons, and he requests some time to place on record the detail of such payment. However, Mr. Day, running counsel for the GHDC, basing on the inquiry report dated
15th May 2017, my lord.
so dated what, Mr. Day?
15th May, my lord. And on the page 4 it is been written. My lord, may kindly produce page 4.
Dated 15 June 2007 inquiry report. This is of the revenue officer of GHDC submitted that the development work on the PW raid was limited within the span of 10 meters from the center of the road. He submits that there was no press acquisition process. There was no press acquisition of land for the purpose of the developmental work of the road, and the question of payment of compensation does not arise. Stop. In the paragraph. However, no, do not say this, however. We just say since the submission has been made by the learned GA that certain amount of compensation has been paid on account of the development work of the road to some persons. Come on, let him produce. Do not say let him. Let the state produce the details of such payment before this court on the next date fixed. When?
After 3 weeks.
Why 3 weeks? List is matter after 3 weeks. Same order will be in that other case also. Yeah, there are 2, 316 and 312. 312 and 316.
Item number
You are
6.
appearing in 316 also, Mr.
Yes, yes. Well, it's an application for deletion of the name of the petitioner number 1 has
it
been
has come
filed.
finally.
My lords. He had expired on 26/11/2021, my lords. At paragraph 3 we've stated.
Yes. Yes, in this case 140. In this case 140. 124. Heard Mr. Paul Arnett, Senior Counsel, assisted by so and so for the applicant and also Mr. Who are those private respondents, Mr. Oh, you left it. Mr. S. Dev for respondent 1 to 3 and Mr. S. Deb for respondent number 426. By this application under can you file an application under CPC in a writ petition?
It should be in the nature of, my lords.
Definitely, should have.
It should have been written in the nature.
Analogous to.
Analogous to or in the nature of.
This is an application. By this application. Or do not say by this application. Say that this is an application analogous to section. Analogous to order 1 rule 10 CPC for striking to the name of petitioner number 1 from the array of parties who expired on 26/11/2021. The learned counsel for the respondents has no objection to the prayer made in the application. It is submitted by the petitioner that there is no one to replace him. Replace the petitioner number 1 in this writ petition as the right to sue does not survive on anyone. Stop. Give paragraph in view of the above, this application for striking out the name of petitioner number 1 is allowed. The petitioner to take steps for necessary correction.
Balance.
Petitioner to take steps for making necessary connection in the writ petition. Stop. The application stands disposal.
Balance. Highly obliged.
Then what to do about the writ petition?
Let it come up after a week, Malaz. In the meantime, we'll take steps.
In view of the writ petition is in view of the order passed in number 143 of 2020. the petitioner shall take steps for necessary correction in the first title of the writ petition within a week. Stop matter to be listed thereafter.
Obliged.
Item number 7.
My lord, this matter relates to section 9.
Land acquisition.
Land
How
acquisition.
many land acquisition matters do you have?
My lord, now in the last occasion, my lordship put a query as to whether a collector can pass a word more than one. More than one.
A what?
A word under section 11. Whether a collector can pass a word more than one under section 11 of the Land Acquisition Act.
More than one means like you could not follow.
On an earlier occasion, lordship put a query to us and directed us to see the law, whether the collector can pass a word more than one under section 11.
Whether there can be more than one award.
More than one award.
Yes.
More than one.
Now that is because I think the situation came to that.
Yes.
That I think because in view of your fresh claim, isn't it? Is it something like that?
Yes. That option.
Is this a case where you said the section 9?
Notice issued to me. Yes.
The only issue is on section 9.
Yes, issued to me and fixed for date for hearing. That opportunity was not given, and subsequently we filed a writ petition.
So the query was not that. The query is basically, Mr. Sangdesho, is confined to the fact that whether acquisition proceeding,
yes,
which is concluded, can be revived
in view of the award already passed.
Just to entertain someone's claim.
Yes, someone's claim.
Who comes at a later stage.
Right. And if lordship entertain that belated claim of any landowner, whether the collector can pass more than one award or not under the same land acquisition process. My lord, lordship inquisitive query reached to that stage.
No, the second query was not yet raised. If I may just clarify, we got stuck up only in the issue of section 9.
That is true. We have argued
and my claim, lordship, was, I still maintain my claim was, neither in the application nor before this court they have produced even any semblance of any documents as to show that they have got a legal right.
At least prima facie to show that they have a
locus
standi basically to one.
Once they have something on facts to show they have a legal right, then the second issue would come whether that's an enforceable right or not. So if they have to overcome first that. No, until unless they overcome that first, whether they have got a legal right,
lordship,
the question of
we have already argued.
No, there was no answer to it.
Argued, but then the way we are conducting hearing in these matters, the litigation matters especially, because of this ground, that ground, things are getting.
It's becoming like a civil court,
and then it becomes difficult for this court to remember exactly what exactly.
If I may just recapitulate,
only the lordship direct them to produce a date of award after concluding almost all the hearing. Now the date of award was directed to be produced. They produced a noting where they failed to disclose the date of the award. And on the last occasion, we argued again. Learned EHE raised that point that without any materials annexed in the writ petition to show the primacy that he or she is the owner of the plot, how writ jurisdiction can be exercised. Now, therefore, I replied that in the writ court cannot go for fishing expedition to ascertain whether the writ petition has a prima facie or not. Immediately, they have issued a section 9 notice. There they mention all the detail of my plot. And more than that, what materials do I need to produce before this court? That was the reply. If lordship tentatively says writ court cannot go to that extent, to what extent of area or the evidence or with regard to title and possession, writ court can go, writ court cannot go. Only the writ court would consider whether the procedure is adhered to or not. After you issue section 9, you say it is a mistake. If it is a mistake, collector is supposed to pass an order that we issue a wrong section 9 with reference to the land document submitted by district council. We revoke that letter notice. They didn't do this. But that was the issue, and therefore we came before this court.
The state contended that this notice was issued on the basis of the report of the district council, but then not on the basis of the section 4 notification.
Yes.
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 So your name did not appear anywhere
appear
in the
in
list
port.
of beneficiaries of
Yes.
the.
Did not appear in port.
But then you are trying to make a claim on the basis of issuance of section.
Yes, yes.
Now,
And
can you show us anything that just because section 9 notification was issued upon you, it should be conclusively regarded that you own certain portion of land in the acquired stretch of land.
Yes, yes, my lord.
Is there any law like that?
My lord, I've seen my lord, so far as my research.
See two things. You may say that the fallout of issuance of section 9 notification, you deserve to be heard. Yes. Now you say you claim that you were there, but then they did not hear you. Yes. But then they say you were not at all there. Yes. And then they have substantiated by referring to your subsequent representation.
Yes. And my representation.
Court is getting.
Yes, memory is my lord, correct.
Yes. So that is where. Now then, in such a situation, we will not go into that disputed things. Okay, only thing is that so far as your claim of ownership of a land falling within the stretch of that acquired portion of land, can section 9 be treated as a conclusive proof of ownership of the land?
No.
And especially as Mr. Khan has contended that there is no details of your land in your writ petition.
But because, my lord, my humble submission, before writ petition, before this honorable court, while filing a writ petition, it is not necessary on the part of the petitioner to adduce all the documents with regard to proving of title. Now, it is for me enough to annex the section 9 notice. So section 9 notice has contemplated detailed mentioning of the land. And they have mentioned.
What happens if a plea is taken that this was issued by mistake?
By mistake, my lord.
They might not have passed any order.
Yes.
They have taken a plea before this court.
Yes. And my lord, in that case, that is what is being. Second is, my lord,
if court get disturbed, yes, Mr. Sangreso, yes. Correct. This is a problem. Right. It's good enough to spoil your mood in a hearing. Are they the lawyers from outside?
Well, perhaps, my lord, the navy be. Yes, so my lord, collector may say that section 9 notice was wrongly issued. And therefore, your representation, which we file after 2 months.
See, if just a bit, yes. just sorry to interrupt. Speaking. Now, the contention is that this issue of this notification under section 9 was on the basis of the documents of district council, which is not at all therefore relevant consideration. This is not at all relevant for consideration of issue. It should have been on the basis of the section 4 notification, where the list of things. So once you have failed, if it is your contention is that your name appears in section 4 and coupled with the section 9 is issued, then it's okay. But then once your name is not there in section 4, then where is the question?
Section 4, when they publish, 57 names mentioned. Then they go for a thorough inquiry, survey, and they receive a report from the extra assistant commissioner mentioning, my lord, nearly, my lord, 70 something. And when they publish the section 9 declaration, section 6 declaration, now the landowner came to 120. Therefore, my lord, the contention of the collector that the listing of the names under section 9, section 6.
All this happened before section 9. 120 names, yes. Section 9, and your name was not there.
But my name is not there. Then? My name is not there. And therefore, my lord, section 120 name mentioned in section 6 declaration. And thereafter, they issue notice to me. Now, my humble submission is that if they issue notice to me on the basis of document, whatever, well, they are supposed to give me opportunity. They do not provide. And thereafter, I file a representation.
No, because of the wrong issuance. Well, how can you see? Well, if you have your claim, make a claim of your own, that is a different thing.
My lord, situation would be.
Claim of your own.
My lord, situation is, my lord, after they issue section 6.
You are trying to take advantage of the wrong issuance of section 9.
No, my lord, I am not taking advantage because my land is missing.
Otherwise you just tell us before section 9 where is your thing? Did you make any claim, any plea?
My lord, they invoke section 17 urgency clause. So
No,
there
but
was
4
no
was
scope for
there.
hearing.
Section 4 was there.
My lord,
Section 4, when section 17 was invoked?
My lord,
when section 4 was...
on the same day they invoked. So there was no scope for hearing under section 5A. And so later on they issue section 6 declaration. And thereafter the sequence, my lord, they issue section 9 notice to me, mentioning all the detail of my name, my plot, my plot's name. Even I can point out the list they have produced now. I can point out where my land is situated. But I don't want to drop out because the lordship will not adjudicate that issue. Now, in view of that, I filed the representation. Collector has enough opportunity to pass an order that yes, we issue a wrong order, a wrong section 9 notice. We relied on the foreign documents. Though the collector himself invited the participation of district council. So we are sorry, we're not acquiring their land. Your land. He did not pass any order in the representation. Therefore, lordship in the last occasion came to a situation where whether at best matter can be referred under section 30. That was one of the options lordship was pointed out. And you can make a claim before the collector, and the collector will refer to the reference court. And reference
there is
court.
an opportunity to do this.
Yes.
Just for exploring that.
Yes, that aspect was there.
Basically, these views come when we find that we do not have a very good case in the writ petition. But then at the same time, you see, do not want to shut down you totally. We want that you should have certain opportunities to raise your views. Now that is what this court was trying to explore. See, and that is what the need of this
data of award,
furnishing of date of award was.
Yes.
Just to determine. But then, Mr. Khan, I think you said that there is no limitation for section 30.
There's no limitation.
30, no.
Section 30.
Supreme Court
so
decision
even
is
that thing also that opportunity will remain there.
Yes.
Lordship, even if
2007
anything happens to the writ petition, even if it is dismissed or no cause of action, still that by operation of law, the section 30
that is statutory right. That is
statutory. No, they can't be barred.
Definitely.
Court will not even debar them. Neither can we stop them.
Court is not required. There is no.
There is immaterial. So whether what happened to the fate of the writ petition has got no consequences with 30.
Instead of agitating this matter before here,
they should have gone there in the first place. I argued before single bench. Lordship, they made a wrong statement before the single bench.
Absolutely incorrect.
The problem came in Lordship.
You took advantage of that wrong statement and got this.
That was the argument of the
Lordship, there was a wrong statement made.
That is very clever of a lawyer. See.
Lordship, Mr. Prasad made a wrong statement, inadequate, and that's why the 18 becomes operational. They took a stand.
You have hit back them with their way.
Yes.
And Lordship, they blew hot and cold in single bench. They said inadequate.
Anyway, it's all right. It's all right.
My lord,
that is where the problem.
We are not the one who is blowing hot and cold. Is it the learned AG?
So sorry, Mr. Sangdosho, please, sorry. Let me reply to it. Lordship, allow me to just reply to it.
Lordship, please.
Mr. Sangdosho, please allow me to reply to it. Let me reply to it.
Be conscious of the fact there are many juniors.
Absolutely.
That is
Lordship, let me just reply to a specific query.
Submission in country to record is incorrect. If learned AG never advanced an argument under section 18, then I'm wrong.
Chapter is gone. Why you are dwelling on that?
Lordship, allow me to just clarify on that part. Lordship, allow me to clarify.
What we could gather is that there are some sort of submission came from your side.
Yes.
Mr. Khan utilized that submission.
Yes.
He's not admitting.
He professionally.
No, we are admitting.
Made the end statement. So we don't need to go there.
Lordship, if I may just clarify.
Some submission. But then why you here on those things?
But we are not in those things. Learned AG reviving that issue because of that, my lord.
Lordship, allow me to just substantiate. Mr. Prasad made a statement, inadequate compensation. Lordship, kindly alert. So that was a stand. No review was filed. The order was not recalled. And then the matter went to division bench.
It's all right. That
No,
whatever
no, Lordship.
That chapter is over.
Absolutely. No, what I mean to say is this. My friend made a statement that I am making an inconsistent statement. Now, without recalling the order, without reviewing that in any adequate pleading, a submission before the court stood much before the division bench. Now, in division bench, an argument was forwarded. It was not the case of inadequate, but no compensation. Lordship, allow me to pause for a minute. Their counsel, petitioner counsel, in one before single bench saying inadequate, and before division bench saying no compensation. Who is blowing hot or cold on that particular aspect?
But it appears that the division bench had taken into consideration the averment made in the writ petition
Absolutely. Absolutely. So that is not the issue involved. No, not
the answer is.
So lordships, while we are arguing in division bench on inadequate, the law is very clear. Inadequate, section 80 will be set into motion. 18. But no compensation, section 30. So there is no inconsistency so far we are concerned.
That is what the law is here. This is clear.
Yes.
But here it is a clear. That is why, see, it is not that.
No, I was just trying to clarify that part of it, lordship.
Definitely.
That part. But the right, coming back to this matter here, lordship, as I submitted, now after the matter traveled to division bench, the issue came back whether 18 or 30. It's a fair concession now, because after the division bench order, a case of 30 can be made out. Because of the pleading that no compensation was made. At least at 30. No, for 30, your lordship, for 30, there is no pleading before this single bench that what are the documents they are relying on for them to claim and mandamus.
See, Mr. Khan,
for direction.
Sorry. For 30, for availing section 30, no avail, as you said, just now you said,
yes,
that no judicial order is needed.
Absolutely.
This is statutory right.
Absolutely.
And then whether a person should avail 30, basing on what document, it's up to him.
Absolutely correct. I'm grateful your lordship. Lordship is correct.
Definitely, whether he has document or no document, that is not at all our concern.
Absolutely correct.
See,
Absolutely correct.
If at all the petitioner contends that his land was taken away and no compensation has been paid, option is second.
Absolutely. And lordship, another argument that he forwarded was.
But then here some additional ground has been made out, yes, because of issuance of notice under section.
Absolutely correct. That is an independent issue, lordship. That's an independent issue.
Now, two things we have to see: whether issuance of the question of law, which
yes,
is that whether issuance of notice under section 9 would mean that the petitioner name was included in the list of beneficiaries prepared under section 406.
Lordship has answered the queries.
That is one query.
Absolutely correct.
Second thing is that what right will accrue to a person
absolutely
who is a recipient of notice under section.
Absolutely correct, lordship.
Now, we cannot just say that just because section 9 has been issued, he has been recognized as a landowner.
Absolutely correct.
Or the person who is in possession of it.
Absolutely correct, lordship. Yes.
Section 9 at the best, if it is to be interpreted in favor of the petitioner, we can say that yes, he deserves a right to be heard.
Absolutely correct. We are not denying it. Lordship is correct.
If there remains a controversy whether he has appeared or not appeared,
yes,
how this writ court will enter?
No, absolutely. That is exactly. Lordship will kindly appreciate.
That is what is your.
That is as I said, lordship. Anything happens to this writ petition, it doesn't mean lordship. We are jumping the gun. There is an alternative remedy. Now the situation, very peculiar thing has happened in this case. That there is an alternative remedy under section 30. Now, irrespective of whether this is pending.
First of all, section 9 basically does not dilute his right under section 30.
Absolutely correct.
Whether it makes his case stronger.
Absolutely correct. Only lordship.
Now
only
you can go to the collector and say,
yes,
see, you have also given me notice.
Yes. And lordship, allow me to just clarify one very important issue of law. When I said there is no document before this court, kindly understand, lordship, I am making this submission with a very full responsibility, because there are two very important law at place. If his submission was that, lordship, whether I produce a document or not, subject to being corrected, whether he made the submission or not, he said whether I produce a document or not, I am claiming my right under section 9.
What is the question?
No.
He right.
Then, lordship, if he says my documents or non-documents is immaterial because rightly or wrongly 9 is issued.
That is so far as locus.
Locus is concerned. Now, lordship will kindly appreciate. If he says, that means he concede that documents is not immaterial for the purpose. And lordship, what is the law on that? The moment he says document is not possible, then lordship, we have a situation whether he has got an enforceable right, when his legal right is not even established in his pleading. Now, to establish this legal right, lordship, kindly just bear with me. I'm just trying to bring in an important position of law.
You are making things very complicated.
No, I'm making it very simple. Lordship. Now, I'll tell you one thing. How will this writ petition lie? His writ petition. If he told was his writ petition to lie, if he says the document, that's a submission. If the document is not important, but only section 9 will give him a right, and there is no documents to prove whether he has got a legal right or not, lordship, then he has to go to civil court, keep this matter in pending, go to civil court under section 35 of the Specific Relief Act, file for a declaratory suit, and then he gets a decree. No, he gets a decree from the court. Then he says, this decree has conferred me a right. On that situation, this writ will
You are
lie.
prescribing a very longer route for him.
That is the law.
Make it simpler.
To make it simple.
Let him go and file an application under section
Absolutely.
30.
Lordship, I'm coming to that.
Just-
I'm
just-
coming
just
to
a
that. I'm coming to
Just
that.
a minute. Section 30. By attaching his documents or whatever proof he has to support his claim.
Absolutely, Lordship. I'm conceding to it.
Referred by the collector.
I have
Once goes to the collector, then the referee court will
That is
take
for them.
on this.
Lordship,
It doesn't have to take that rigor of going and filing a suit. to
no,
the
I am
Supreme Court.
just trying to extend the consequences of the argument that he has forwarded. We can keep this matter pending for next 10 years. Let him get a declarative suit and then says yes. And amend his writ petition.
This court will not keep it.
Absolutely. No, if that is a submission, if that is not,
Anyway, these are besides the thing. You see, two things. What prima facie, if you talk about locus standi, you will definitely
Yes.
see the petitioner as a locus standi because
Yes.
rightly or wrongly, he is in possession of a Section 9 notification issued.
I fairly concede. Lordship is correct.
Now, what right accrues by virtue of that Section 9? That is
Yes, that is the only issue. Lordship, I conceded in the that day also. I said like we can make the matter very short. Irrespective of whatever happens, this only thing this Lordship, it's free from your Lordship, that can we give a direction? I said Lordship as per law.
Now, one thing is that you see the filing of question of filing an application under Section 30 would come when the petitioner is aware about the existence of a award. Now, how that is to be determined here.
Lordship,
now, if petitioner contends that there was not award in existence,
but Lordship, that hurdle can overcome because there is no period of limitation.
then how do we decide on the date of award?
Lordship is correct. Had there been a period of limitation, then state would be in a back foot.
But even in that case also, we can say that at least right now they have a knowledge, and
Lordship
they
is
can
correct.
approach.
Lordship is correct. We have brought in record.
Mr. Sanglesho, that seems that the
Sim-
only solution. Go and
So
approach
we've
the
been dragging
collector
this
on
matter for so long. The issue is very, very simple. His right is not eclipsed.
This court, in any case, even
Not
if you are
eclipsed.
able to make out a case, will not be able to give you any.
But my lord, with due
Except for
respect,
directing you
To approach
or
the
not barring you from approaching.
not barring it. Lordship is correct. Not barring it. Only on the basis of Section 9. Yes.
earlier three petitions Lordship has just heard. There was also order by this honourable court to conduct a survey and report of the survey be submitted. I was praying for that, but Lordship was not inclined. Therefore, I am not raising that
earlier
point.
occasion, on
Yes.
earlier situation,
But-
passed
Facts was
some
different.
order of
I'm not
inquiry
raising.
and all. That order would not bind this court.
That is
to
true.
Pass
That is
an
true.
order of inquiry.
That is true. Not binding. Not binding.
You see,
but
it
for
depends
satisfaction.
upon, you see, like this, matters are hard by different. At
The
different
facts
time, at
situations
different
are very
situation,
different. Lordship.
and by different men.
When learned
that-
the AGR quite did not interrupt him. I just want to clarify. Section 30, the limitation, my lord. 2007 Supreme Court order is very clear. I've given the
What
list
does it say? What does it just tell us?
Yes, yes. There is
There
no
is a
lim-
limitation prescribed.
there,
for that.
there is no limitation period for invoking Section 30.
That is all right.
Therefore,
Then settle
within a
question.
within reasonable time, party can invoke. So if Lordship is persuaded, my lord, to refer my matter to invoke a Section 30.
We will not refer. We will just give you the liberty.
Absolutely
My lord,
correct. Yes.
Lordship,
We are grateful,
We
Lordship.
will say
Yes.
that there is no bar for you here.
Lordship may kindly, my lord, keeping in mind, my lord, the plight of the petitioners, the deprivation he has to prove before the reference court, the authority. My lord. Now, Lordship may keep in mind, the collector is the author of the revenue document, the land acquisition document. He has given me a notice. He never disposed of. The citizen come forward claiming the filing representation. He never disposed of, contrary to law. Law is very, Lordship is very clear. Whenever citizen file a representation, executive has no power to keep
No,
it.
it depends. You see,
My lord,
just
now,
because
and-
the representation is filed, that should be responded. No, there is no such.
my man,
You filed some unnecessary petition. Do you think an officer will
no,
waste
my,
his time in
my lord,
replying you?
in my case, this is not unnecessary. In responding to Section 9,
That is
we are
what you say.
passing.
That is what you say.
Right.
But then your conduct matters. When you receive a Section 9 notice, and when was your date of appearance?
We appear.
And when did you file your representation? What is the gap?
We appear, my lord. And after few
No,
months,
that
my
is
lord,
denied. That is denied. And if you had appeared, and if you were not given a time, why you did not file a representation immediately thereafter?
My lord, here nearly 2 months gap. A month, not a long ago.
2 months is not a gap, you just say.
It was fine. It was
Knowing
fine.
very well that a proceeding is going on.
My lord, that is, Lordship, I would concede that there was a lack of sense of urgency.
See, there are certain things, factual aspects. I don't think even your caliber will not be able to cover.
No, my lord, I understand, my lord.
No.
I'm not deploying the whatever caliber.
Even if you give your best, see certain factual aspects, definitely not.
My lord, I do concede.
Now, the thing remains is that even if we accept your submission, tell me what kind of relief can be given by this court.
My lord, my prayer is, my lord, to direct the authority to take appropriate steps under the Acquisition Act and pay compensation. Now, Lordship is refused. My lord, looking to the
Section 30 is there, the Self-Contained Act.
Yes, Section 30. There was Section 30, my lord. If Lordship desired to pass an order, my lord, keeping all this keep in mind, collector pass an award, no date is maintained. And my lord, for determination of the subsequent action,
we'll say that is the reason for you not preferring
but
the position on this.
therefore, my prayer is, my lord, since the statute do not provide this limitation period, my lord, liberty may be given to the petitioner may be allowed to file an application invoking Section 30 within a reasonable time, within 1 month itself, and direct the collector, my humble submission, to give a coitus to the issue, direct the collector to pass appropriate order, keeping in mind the provision of law within 1 month thereafter.
In accordance with law, that is what.
You can do that. Otherwise, why do we need to go for the locus standi?
We are not going to locus standi. We say that there is a locus standi.
Yes, exactly, madam.
This court is totally in agreement with you.
Exactly, madam.
Once you are a holder of Section 9 notification, you have a locus standi.
Exactly.
Okay. So, that is what.
But the rest of the submission of the side is academic only. It's not relevant.
How many petitioners are here?
But not here, 4 of them only. My lord, may I just cite 2000?
All of them have received this Section 9 notification?
Yes. All of them. It just indicate the Section 9 notice which they have received. My lord, we come to writ petition page number 125. Well, writ petition number 1. And the detail of the land they mentioned, my lord, given that PKL, this is the nature of the land, they describe.
This is 1%.
To the writ petition number 1.
Yes.
So earlier submission of the respondent that the detail is not mentioned, that is incorrect.
Then next is number 2.
Next is number 2, revision number 2. And page number 117 is W number 3. And 128 is a revision number 4.
Mr. Khan, one thing is that you see, like that award has no date. That is something I do not know. Have you communicated to your department how it has come?
Lordship,
from your side, you should do.
I have fairly considered, Lordship. We receive instruction. There is no date.
That is all right, but then you should tell the department that how come this kind of negligence?
We've informed, Lordship. In my personal capacity, also I'm informed. Absolutely. Yeah, I leave it to the court. That we are fairly considered. We have checked the records.
Very unusual.
Very unfortunate. Unthinkable, Lordship. This thing should have happened. No, Lordship, if, as I submitted, Lordship, had the date of award would have been crucial, limitation would have come in the middle, then court could have molded. But there is no bar. So for the date, the consequences of no date eclipsing the right of a petitioner. There is no limitation. So the date or no date for the present case is inconsequential. Yes, for the larger purpose, Lordship is correct.
But then this is very
unfortunate. I admit, Lordship.
See,
the record speaks.
It's a government record.
Absolutely correct. Well, there is no consequences.
If there is any claim under Section 18, then the question of limitation.
Absolutely correct, Lordship. That would have been then.
In the present case, the date may not be much relevant.
Yes.
We cannot say that it is correct.
Lordship is correct. But if it would have eclipsed the right of petitioning in some way, then Lordship would have definitely taken cognizance of it. For this present case, yes. Otherwise, generally, Lordship is absolutely correct.
Very hard, Mr.
Keep in mind the 2007 judgment, which I have placed.
What for?
For my satisfaction regarding the invoking of Section 30.
That is not required.
We concede. We concede. We are not.
Can you reflect Otherwise, the collector may say, my lord,
When you file your claim application, you refer that.
Lordship, I
That
can,
also you
can
can
refer,
do.
but since we, my lord, apprising, my lord.
Part Mr. Sandesh, your lord and senior counsel, replying with the petitioners, and also Mr. Sandesh, assisted by Miss P. Vishwakarma. Vishwakarma. Yes, by so with petitioner and also Mr. K. Khan, appear along with Mr. S. Sankipto. Mr. K. Khan and 100 AG appear with Mr. S. Sankipto for additional senior government advocate. The grievance raised in this petition is with regard to non-payment of compensation to the petitioners. In consequence of acquisition proceedings drawn by notification number RDA capital stop 21 where is that notification, Mr.
Page number 110, my lord. Section 4.
Yes.
Notification. $110.
That page 2, I think, isn't it? No, this is joint survey. What is the notification under section 4?
Section 4, my lord. 110. I'm referring to 110.
110.
Yes, 110. In section 4, they have mentioned in 112, page 112, along with the urgency clause. Portion, the last at the bottom.
Yes, just see on the page 110. You see on the top you will get the notification number RDA stop 21 stroke 2012 stroke 52 dated 14/3/2013.
Yes. Mentioning 56 names. And section 6 declaration is page number 113. The next page is there.
Just a minute. What we said, just say in consequent to the grievances raised in this petition. Consequent to the drawal of not consequent to the drawal of a litigant proceeding by notification. Just okay, just to maybe notification issued under section 4 of the LA Act of so and so. Notification dated so and so, issued under so and so, okay, under section so and so, and notification dated next is 113. Okay, notification number RDA 21/2012 stroke 83 dated 23/5/2013. You just see from page 113 for the petition. Issued under section 6 of the LA Act. Stop. For acquisition of land, it is for the purpose of what?
For the purpose of a
okay. For
construction of two laning.
For construction of two laning of Shillong Nongstoin, section NH 44 and Nongstoin dash Thura State Road under phase within inverted comma right capital A of SARDP all capital stroke any. This also you will get in page 110. Okay, in the front part. Stop. The contention of the petitioner is that they hold certain stretch of running land, certain stretch of land running along the said highway, but their name was not included in the list of beneficiaries. For payment of compensation. Stop. The petitioner also further contended that during the course of the proceeding, notification under section 9 of the land
Section
division
6, madam.
Huh?
Section 6, before section 9 notice, they issue a section 6 declaration.
Section 6 we have already said.
Oh,
Section 9 notification was issued to the petitioners, asking them, requiring them to appear before the collector. You can do to appear for the collector. For stating the nature of their interest in the land acquired and the amount and particulars of their claims for compensation. However, in spite of issuance of section 9 notification, the petitioners were not afforded an opportunity to be heard. Although they were present on that day fixed for their presence before the collector. The petitioner further contended that pursuant to the petitioner further contended that after what is the representation, Mr. Sangresha? What is the page?
Page number 129.
Yes. The petitioner further contended that the representation, page 121.
120. 129.
Or 29. What is it the last time? It is dated 13th. Petition or some everywhere this things. 13th October 2013 was filed before the filed to the collector. For affording them a chance of hearing and for payment of compensation for the land, for their land, for their land. For their land taken by the acquisition proceeding. Taken over by the but the collector did not bother to consider the said representation. It is further contended that petitioner had no knowledge of preparation of any award in the said acquisition proceeding, and because of that was not in a position to raise any legal grievance against non-payment of non-inclusion of their name against non-inclusion of their name in the list of beneficiaries and non-payment of compensation to them. It is submitted that the collector is under lawful obligation to consider the plea of the petitioners once they were issued with a notice under section 9, and since the collector had proceeded to pass to proceeded to prepare an award in the matter without performing his lawful duty under section 9. A direction may be issued to the collector to consider the claim of the petitioner and pass necessary order for payment of adequate compensation to the petitioners. Paragraph submitted that the petitioners have approved this court without stating without giving any details of ownership of their ownership of the properties came by the petitioners, and there is no document appended with the writ petition to writ petition in support of the claim of the petitioner, or do not say to support, to project that the petitioners hold any piece of land in the stretch of land acquired by the government in connection with the construction of the, what is that road just mentioned from there, NH so and so, okay, in connection of the such road. The learned AG contends that in view of in absence of any prima facie proof of, in absence of any prima facie proof of ownership of land of the petitioners, this writ petition should not be entertained. The learned AG further submits that the Section 9 Section 9 notifications were wrongly issued to the petitioners, and the said notifications were not based on the list of beneficiaries appended to the notification under Section 4 and Section 6 and the Land Education Act. He further contends that issuance of Section 9 notifications do not create or confer any right on the petitioner to claim compensation in absence of any statement, in absence of any specific statement and disclosure of properties, of respective properties of the petitioner. It is also the submission of the learned AG that if the petitioners have any claim of compensation, claim of payment of compensation with regard to the acquisition of land, in such a case what is it, if the petitioner has any claim payment of compensation. Come on. No. They should seek for remedy available under the provisions of the Land Acquisition Act and not by filing a writ petition. He submits that there is no merit in the writ petition, and the same deserve to be dismissed forthwith. Stop. During the course of the hearing of the matter, the state respondents were asked to provide detail of the award prepared in connection with the aforesaid land acquisition proceeding. In connection with the said land acquisition proceeding, the production of record revealed that though an award has been prepared in the matter, there is no date reflected therein. There is no supporting document also. There is no supporting document. There is also no supporting document which would which directly or indirectly show the date on which the award was prepared. The learned senior counsel for the petitioner was right in contending that no, do not say learned senior learned counsel for the petitioner contention that the petitioner had no knowledge of passing of decree appears to be correct in view of the fact that no date has been mentioned on the award. You have paid compensation to all the persons you have already. Yes. However, the materials and record reveal that the amount of compensation has already been paid to all the named beneficiaries in the acquisition proceeding. Stop. the spectrum of payment would definitely show that an award is in existence, although no date has been mentioned in it. Give a paragraph. The contentions raised by the petitioner in this matter are with regard to their claim, are with regard to a non-payment of compensation with regard to their land claim to have been acquired by the state. The state has vehemently objected to the claim of the petitioners by saying that they do not hold any stretch of land falling within the acquired portion of the land. Now, stop. The dispute appears to be such, which is specifically covered by section 30 of the Land Distribution Act.
It would be 76 as of now. 76.
But then this is under this proceedings.
My lord, under all Act, section 4 and 6,
76
determination of the award.
One second. I think the law says when it comes to preparation of the award, then only the provision of new act has to be followed.
Yes, determination.
But then otherwise section 30 and all will be in operation.
My lord, no, my lord, the section 30 now converted into section 76. Now the data, the award, for determination of award, the section 24 of the new act, it says, if the award was not passed at the arrival of the new act, then determination of the award would be under the new act.
But then this award is passed on the new act, isn't it?
New act.
So that is what. So whatever it is, the thing is that the fact remains that the proceeding which was initiated under the old act, it continued till the new act came into force.
Yes.
And the award was prepared only after the new award came into force.
Yes.
The law says that if any proceeding is initiated at the time when the old law was in operation, and the award is prepared when the new act came, then only the award has to be prepared by taking into consideration the assessment of the rates which is prescribed in the new act. That is what, nothing more than that. Other things will be other things. Anyway, we can see what we said.
Lordship, section 24. But it is very clear. Lordship, I have taken the pain to see the section 24 of the new act.
See the section 24. There's no question there. That is what it says. Only it says that you have to prepare the award by taking into consideration the provisions of the new act. Nothing else.
Yes. Lordship. 24, by
Yes. But then
section 24 is very clear. Lordship. Notwithstanding anything contained in this act, in any case of land acquisition proceedings initiated under the acts and such, where no award under section 11 of the L Act has been made, then all provisions of this act relating to determination of compensation continue.
Yes, determination of compensation.
Determination. So
Section
in my
is no determination. Determination would come when the rate is calculated.
My lord, therefore, technically, if I move an application under section 30, that means surrendering to the old act.
See,
so
then we will just say that's what
section 76.
What does it say? It appears that we covered under section 30 of the Land Distribution of 1984. comma, and under section 76 of the Right to Fair Compensation and Transparency in Litigation, Rehabilitation, Resettlement Act 2013. Stop. Both the aforesaid provision of law mandates that whenever any claim is to payment of compensation is made, the aggrieved party should approach the collector referring what you said, both the provisions? No. Both the provisions contemplate that when the amount of compensation has been settled, and there arises a dispute, as to the apportionment of the same, or in part thereof, or as to the person to whom the same or any part is payable, the collector may refer such dispute to the decision of the court. Or the authority. When Mr. Shangdesh will otherwise stand up again and raise this objection. In the present case, it appears that though the petitioner has filed, though the petitioners have filed a representation to the collector, which was not responded, they have not filed any application in terms of section 30 of the old act or the section 76 of the new act. See, earlier where you mentioned the name of the act, just within bracket, when you say old act, then there is a new act, where we have referred to that. Okay. As the land acquisition, as both the acts have inbuilt mechanism in it to tackle with the issue raised before the state court. It would be, it is deemed appropriate Shall we relegate them, or we can
My humble prayer, my lord, if the lordship direct, my lord. Since the matter is kept pending for long, and both sides, we can see both sides some shortcomings are there, but in view of the fact that, my lord, the LA is a social
The
legislation.
question is that shall we pass a clear direction or shall we make it open to you?
I pray for direction.
Lordship,
Involving the relief.
liberty may be given as per law. As I said, that
What we said, what we said, that since both the provisions have inbuilt mechanism to deal with the issue raised before this court. It is this court, at this juncture, it is inappropriate not to pass any specific direction in this matter. In this writ petition, as no prima facie case has been made out for such a direction. However, considering the fact, however, taking into consideration the nature of grievance raised in this writ petition, especially since it concerns the landed property of the petitioners, it would be open for the petitioners. After comma, it would be open for the petitioners to approach the collector in terms of provisions of section 30 of the old act or section 76 of the new act for seeking reference of the matter for determination by the court or the authority. Stop. Since the award passed in the matter did not contain any date, and there is nothing on record to show that the petitioner had knowledge of passing of such a word, it is provided that in the event of filing of any such application for reference by the petitioners, the same shall not be rejected on the ground of delay and laches on the part of the petitioners. Step. The collector shall take into consideration the merits of the case when discharging his duty under the aforesaid section of law. The paragraph with the aforesaid direction, this petition stands disposed of.
But I pray for some time frame with the collector. It will be delay again, 1 or 2 months.
Then before these things, before the last line, okay. In the event the petitioners decide to file an application seeking reference of the matter, the same shall be done within a period of
1 month.
1 month from today. collector thereafter. The collector, upon filing of such application by the petitioners, shall dispose of the same within a period of
Yes, within 2 months.
within a period of 2 months thereafter, with prior intimation to the with due intimation to the petitioners. Then will come with the opposite direction. There may be some polishing here, there, miss out many things while dictating.
Lordship, one small fact need to be corrected. I said all the compensation was paid, Lordship, as the query.
Yes.
So the information we received on 28th July, Lordship, out of 120, 118 was paid.
So the compensation to most of the
118.
of the thing. This is only for the purpose of determining.
Absolutely,
Since there is
absolutely,
no
Lordship, yes.
that there is some award.
Yes.
Is somewhere we have said all the compensation?
Only 118 out of 120.
Any confusion, you keep it blank, come in my room and we'll just see it. Thank you. At least but then this could have been done before, right? There have been a consensus on this thing before. Because there is no other option, Mr. Sambesho, at least so far as this court is concerned. Very difficult. This is not within the power of this court to pass an order, directed payment of some award. The moment we do it, Mr. Khan will run.
And as it is, Lordship, a lot of athletic seasons are going on in the Olympics. Running time is on.
He is hinting it right from the before, right from the start. That say you cannot pass any order.
Out of the record, whether it has a appetite for academic discussion. Very important discussions it is.
Yes.
No, but we're grateful, Lordship. At least justice has been done, both sides, absolutely, as per law.
That is only.
And if he's entitled to, is justified to, Lordship, this state will not stand in the way.
Definitely, we hope that collector should not be biased. At least he should take this.
No, absolutely, absolutely.
And support your things by this thing.
Yes.
Do not come without document which you come. Then again, Mr. Khan will advise them not to entertain.
On a lighter note, Your Lordship, I thought if he was forwarding that argument, I just extended the argument. He needs to keep this in appearance and go to trial court. Oblige.
Chiefly obliged.
Oh, it is 100 to 130. Yes. How many matters are ready for hearing?
Well, number 10 is left, my lord.
Okay, so you will take it up. If you take it up, then you have to give me some time. I have to take food and come back. I am feeling hungry.
Well, I was requesting for it can be taken up, Kishore.
Provided you agree, both of you agree, then we can. What is that item number 10?
This is conviction by the BSF court, my lord.
Third stage. Tomorrow cannot. Then it has to go to next week then in such a case. Who is appearing for the petition?
Mr. Kishore Gautam. He was here.
Mr. Gautam, yes.
Sorry, just waiting.
He was good next week.
Well, because learned senior is also not well. The only thing is, my lord, here I've already spoken to learned senior also. Two aspects of the matter. My lord, the writ appeal will take the writ petition will take quite a lengthy hearing, because my lord, here evidence also has to be looked into. My lord, this person has been inside this already completed half of the sentence imposed on him, my lord. And that's very recent judgment of the Supreme Court also is there, my lord, that there is a misapplication pending over here for suspension of sentence. But if that can also be taken up, my lord.
No, you see, the thing is that if you are ready for final hearing, where is the question of hearing it in piecemeal?
Well, I have been ready for quite some
Taking
time.
time means taking time for your argument, isn't it?
My lord.
That is once. This court till now has not delayed passing of judgment in many things. See, if it is not that complicated. And you were there. So
but this is a little complicated because, my lord, this is a finding of the BSF court. My lord, this is not a normal criminal appeal.
But then, even for considering your interim prayer, you have to go to the merits.
Yes.
But I will place that merit also. But my lord, that will not be a very lengthy
We
hearing.
have both the options. If there is any difficulty in disposing the main appeal, then we may consider
that. May be taken up next
but
week, then, my lord.
It should not be something like that you start an argument with purpose of usually like consideration of interest. No, that should not be. We'll go for final disposal.
My lord, then in that case, next week.
Next week. Just say the request made by the parties. Let's meet this matter in the next week.
In case, my lord, if the petition cannot be taken up, then at least submission on the miscase may be taken up.
This will keep in our mind. You
My
remind us.
Lordship.
But then, why, Mr. What is the problem in taking a final hearing?
I have no problem.
So then,
Only because of some health issues.
Dr. Mojika is ready. You are always ready.
Yes. Well, because of his health issues, I don't want to press also. Today also, I think don't need to give much time.
Definitely. You are all right now, Mr.
Now recovering.
Your smile is there. Yes.
Deeply.
Obliged.
Yes.
Well, item number 9. In this matter, I think the government was supposed to reply on certain issues which relate to the transfer of the teacher from one school to the other, and we had challenged the termination.
Yes.
The court had put certain queries on the government. They were,
What are the queries? There are certain instructions to be obtained by you, Mr. Hazarika.
No, then private respondent also might whether he is still in the service or not. 7 and 8.
Are you ready for hearing then?
Today, after a week.
It's up to you. You see, if you are ready for hearing, then we'll come back after having.
in fact, the main contention is that the government has to reply.
That is all right, but
That's the
it's,
thing.
it's all right. Government has to reply. Government will have to. If government has to reply, they will have to reply.
Yes, sir.
So we'll have to think. This court has forgotten what was the issue.
Yes, ma'am.
You have to refresh our memory.
Then let this matter come up on 13th.
We'll not give you a fixed date after a week.
Yeah, because some important matters are there on the fix. So I will just request.
You see, you have juniors. We can accommodate. See, normally this court, you see, this court is there for hearing
Yes,
every day. If you have 1 day difficulty, you can have it in next day.
My lord.
Since we are not
Correct.
You see, like giving that privilege of giving
Correct.
these things. If we give this, then once we start that system of giving fixed date, then
Correct.
there will come up.
In fact, there was exhaustive hearing on this, but after that,
as prayed for by the parties, this is not up to you. We'll have it. We'll just try to finish it, Mr.
my lord.
One matter is there.
Item 13, the last matter.
Yes.
The issue is still pending before the division bench of this honorable court regarding
matter.
quashing on basis of compromise.
Yes. You are supporting the case. But then
My lord, I am for the petitioner, my lord.
Yes.
My lord. My lord, the issue is pending in higher courts, my lord.
Yes, yes.
My lord, we need more some more time, my lord,
Yes,
to obtain.
We'll have it after 3 weeks. 3 weeks.
My lord, my lord.
Yes. On the joint request made by the parties, list this matter after 3 weeks.
Good luck.
Good luck.
Nothing more.